County Council Committee of the Whole meeting for Wednesday, September 28th, 2022 is now called to order. Andrea, would you please call the roll?
Good afternoon, everyone. It is now 2:05 p.m., and as a reminder to all in attendance, this meeting is being recorded and live streamed on the county's YouTube page. Calling the roll, Mr. Sweeney. Present. Mr. Tuma.
Here.
Mr. Gallagher. Mr. Gallagher is absent. Mr. Schron.
Here.
Ms. Conwell. Ms. Conwell's absent at the moment. Ms. Turner. Ms. Turner's absent at the moment. Ms. Stevens. Ms. Stevens is absent at the moment. Ms. Simon.
Here.
Ms. Baker? Here. Mr. Miller?
Here.
Council President Jones?
Here.
You have a quorum.
Thank you, Andrea. Andrea, has anyone signed in for public comment?
Yes, we have one public comment, Mr. Evan O'Reilly.
O'Reilly, please come forward.
Can you push the green button, Mr. O'Reilly? Thank you.
I'm here once again representing the Cuyahoga County Jail Coalition. I know
if you could just state your name for the record.
Yes, Evan O'Reilly. I know you have a very difficult decision in front of you today. I know you've had a lot of people come and talk to you about this jail. A lot of it has been kind of a bird's eye picture, so I just wanted to share one story that I think is important that was shared with me that I think kind of gives a more human perspective. So Shondo Moffitt was the most recent person to die in our county jail. He passed away at the end of April of this year. Shortly after, our coalition, through his attorney, reached out to his widow, Linda, and she basically talked a little bit about what this experience was like for her family. So my understanding, based on the county clerk of court's website, is that Mr. Moffitt was at the county jail for a failure to appear warrant. These happen to people for all kinds of reasons. It's definitely a difficult thing to square if people don't show up for court, but I know very often people don't even realize they had a court date scheduled when these warrants are issued. I also know that people have had these warrants issued while they've been detained at the jail, just because we have different systems not communicating with each other. He was undergoing treatment for kidney cancer at the time. He was still the primary breadwinner for his family because his wife was going to nursing school. After his arrest, she had to drop out of nursing school and became the sole source of income for her 4 young children, the oldest of whom is 10 years old. The press at the time, and I believe the county statements, said that his body was found near a white powder. The investigator who examined his body reached out to Linda personally to say that this was not true, and they saw no such thing. What happened was 2 weeks prior to his death, he requested a medical release from his judge, Kathy Satula, which was denied. This is pretty much standard operating procedure from what I understand. Very few judges would grant that kind of request, but it was known that he was undergoing treatment for kidney cancer. And as I understand it, he passed away from kidney failure 2 weeks later. His family, his parents and sister and Linda arrived at the hospital. They were not allowed to see the body. They were told that Shondo was still considered to be in county custody, even though he was dead. And I say all this, we were able to help them out a little bit. We raised almost $6,000 for her family, but I know she's still struggling. This is a very difficult time for everybody, and she lost her, the primary breadwinner for her family. So I say all this just to remind you, as they make these decisions, that it's never simple, and there's some very real human pain at the root of all of this. Thank you.
That concludes the public comment portion for this meeting.
Items referred to committee.
Ordinance 0-2022-0008, amending Chapter 1501 of the Cuyahoga County Code to prohibit discrimination on the basis of reproductive health decisions.
Someone to present this, speak to this matter?
Good afternoon, Mr. President, members of the committee. Matt Carroll from the Executive's Office. As you see before you, This is an amendment to the existing non-discrimination ordinance, Chapter 1501 of the Code. It is in some extent, as noted in the whereas clause, a response to the recent Supreme Court ruling, and it's part of the measures that the county has taken to respond to that outcome. That includes the item that was passed in Board of Control related to services and the funding that went to the Center for Community Solutions. Also, today's note to employees about how they can get care related to reproductive health. And then this amendment would be a way to slightly expand or add to the definition of the term we use, the phrase we use in the ordinance is because of sex. And that would include, or this amendment would add to that definition to include reproductive health decisions. So the big picture is that the way the rest of the ordinance does for other types of protections, that you shouldn't be discriminated against because of a reproductive health decision, as defined in the language you see before you. This proposed amendment is modeled after something the city of Columbus passed, I believe last year, before the ruling. And it's an attempt again to just add to the protections that a county resident would have to exercise what is really a health-related decision. Of course, this would proceed through the Human Rights Commission process, and as is noted in the amendment, and similarly to how it works today or how it would work today. But that again, you have the language before you. The most relevant part is on page 5, where it redefines the term, as I said before. It goes into more details related to that. And I guess the last thing I'll say, and be happy to address questions, and also we'll rely on legal counsel as well to help fill in missing information. But I think we view this as a practical health matter, that there are people that will be seeking these types of health services. And we, I think, want to make, our point is to make the statement that they should not be discriminated against for what is a practical need and a health-related sort of priority. So that's really the purpose of being here and why we have put this forward today. So again, happy to answer questions. I don't know if Law Department wants to add anything, Greg? Okay.
Matt, this prohibition, will this apply for county employees or is it county-wide?
So this is similar to the ordinance. It's in the ordinance that provides the rights that you can address through the Human Rights Commission. So like we've done before, adding certain types of protections. So it's the same kind of thing. A county resident who is discriminated against in the way described can bring it forward to us. Yeah, it's meant in the same way.
All right. Any questions from council? Councilman Sweeney.
Thank you, Mr. President. Thank you, Chief. Thanks for bringing this forward. Just, you mentioned a couple times, as we have done before, and I probably wasn't here when you did it before, so I'm just through my president. Who's the enforcing entity? How do you, is it a step process? Because I know with the OEO stuff, it starts in HR, but then they can file separately. And what's the discipline of the offending entity, kind of stuff like that? If you can do it in a snapshot so I can get caught up to
Sure,
speed.
Councilman, I haven't been through the process myself, but we created a little while ago the Human Rights Commission, which provides a different kind of redress for discrimination that takes place in the county. And it's not, I guess the lawyers would call it extrajudicial. So it's not a court process. It's a internal county process that allows you to bring a case forward for, say, employment discrimination or some other housing discrimination is covered pretty heavily in here. But we have 3 members of the commission that we jointly appoint, and they will hear the items that are brought forward. There's a process that's outlined in the Human Rights Commission setup for basically a case, you would call it, to come forward. And then there's some county-provided remedy. I forget the exact details. Maybe Greg could help with this, but there's a remedy that the county provides once something has gone through that process, and the commissioners have heard it and ruled. There's actually some discovery in that process, and it's like a legal process, but it's internal to the county.
And thank you. May I continue a little bit?
Continue.
Thank you. So do the employees that are our coworkers, do they know about it? Is this something that's HR that says, this is created, it's new, we remind them every paycheck or once a year when the handbook comes out, or when a new employee comes in, they say, this is what it is, and kind of highlight it?
Through the chair of the councilman, this is for this is for any county resident.
Yeah.
So the Human Rights Commission is there. As far as notifying our employees.
That's what I was focused
Yeah,
on. Because
I'm not sure that how often we provide that information, but that's certainly something we could do.
Yeah, because it's something that
Right.
is a
Right.
wonderful thing for Cuyahoga County residents, but also our employees. And through the chair to Matt, or Director Carroll, if the offending entity is a county worker, does the commission have the authority to say something happened, it was not appropriate, not right, so that person that caused the action, are they subject to what authority?
Through the chair, Councilman, I believe that if you're an employee of the county, you would proceed through the regular HR process and get your protection or your process there. There could be a circumstance, I guess, where an employee would go through this, but I would imagine it would start with the HR process. If you would allege concern, and it would be sort of reviewed through HR.
Got it. And I'm just talking about on the discipline side, if they were caused some harm, somebody did it to them, and that person would, I'm just trying to see how much teeth this human.
Like I said, that would fall under our HR rules, not necessarily the Human Rights Commission.
Thank you, Chief and Mr. President. Thank you.
Mr. President?
Councilwoman.
So for clarity purposes, the original anti-discrimination ordinance focused on 3 different areas and sectors. One was housing, employment, and public accommodation. So what that means is the county-wide has this applicable to housing discrimination, employment, public accommodation. So when we add this provision based on sex, pregnancy, any medical decisions relating thereto, how does that actually come to play, Matt, Director? I envision this if somebody was kicked out of housing, a woman wasn't able to go into housing because she's going to have an abortion. What's your vision for this? How does this relate to Dobbs and in all 3 of those sectors?
Through the chair, Councilwoman, I would imagine that in a housing situation or an employment situation or the other public accommodation, that if an authority made a decision on your status because you went to another state to get reproductive health care, that could be, that might be more obvious in an employer situation. You could potentially see an employer taking that approach, but I would say it's also possible in those other 2 settings as well. But if someone in authority makes a decision that affects your rights in those areas, then a person could have redress with the commission.
So an employment claim, somebody was dismissed or couldn't get housing because of that decision.
Right, if that were part of the decision, yeah.
Or served at a public business.
Right.
Okay, so that's really, we went through this when we originally passed this, the 3 sectors. So this just is adding a different protected class, basically.
That's right.
Let the record reflect that Councilwoman Meredith Turner is in attendance. Councilman Chuma. and
Thank you.
Councilman
To
Miller.
the director. What maybe this is more suited to the law director. What legal teeth does this amendment have as far as moving forward with this as far as enforcement goes, because, I mean, knowing how our state currently is, we couldn't even have a plastic bag ban in place without the state legislature getting involved. And I couldn't imagine some of those folks who have viewpoints from 1883 allowing something like this. And that's not all of them, just the majority.
Mr. Chairman of the Councilman, I'll have to confess, I didn't bone up on the actual fines that are available that are imposed by the commission. But currently, this is not something this is something that we can regulate. This is an area that we can regulate in. And in the past, when issues have come up, what the Human Rights Commission has tried to do is get the parties together to negotiate a solution, and mediate a solution. But in any event, when a decision is handed down by the commission, it can always, of course, also be appealed to the Common Pleas Court under what's called 2506. It's a civil appeal.
Okay, I appreciate that. But a second component of this, I just have to ask. So, with those other instances, if you're discriminated against based on the other criteria we have in the ordinance, I think you're probably a little more willing to bring a claim. But in this instance, I mean, this is a very private matter. Mm-hmm. So how do we protect the privacy of the individual bringing the claim? How does, it's a concern to me as far as the privacy issue, because
that's a good question.
Through the chair, Councilman, I believe the Human Rights Commission's public body, they meet publicly. Right. There in the discovery part of it, maybe there is a way to address some of the privacy issues, potentially like you would in another. But I do think it would necessarily have a public element to it.
Yeah. Mm-hmm.
Okay. That's a consideration, as far as practically implementing it. So just something to think about.
And I would just say too, as the law director said, the idea is to potentially mediate sometimes, yeah. Mm-hmm. and to address these things without it having to go to the formal process.
It's Councilman Strawn and then Councilman Miller.
Thank you, Mr. Chairman. Some of these things I thought were already covered. Isn't breastfeeding and pumping covered at a national level? I believe it already is. I know that we provide rooms for women for breastfeeding and pumping during those early stages of after the birth. So I'm not sure what we're adding here that's not already covered in legislative format. It just how many cases on the Civil Rights Commission have we actually encountered since we created this?
Do you know, Greg?
I'd have to check. I mean, I know.
I wasn't aware of any.
It's not a large number.
Are there any yet?
I'm not aware.
There have been at least two.
Okay, all right.
Yeah. Mm-hmm.
So,
Councilman, I can't speak, maybe Greg can speak to this. The addition of breastfeeding or pumping might have just been a cleanup to clarify. Yeah. Mm-hmm. I think that protection was there, but the other detail is the more salient part.
And the reason why I'm separating that is because I think that's already covered by federal legislation. So then what we're adding is a number of other items in here, and you finish this off with there's no requirement to provide any of these things. So if a private industry were to say flatly, we're not going to cover everything in that's listed there except for breastfeeding and pumping, would that be discriminatory?
So it's Councilman, it's making a decision based on somebody's health choices. So if a person decides to go get these services, so in Ohio you couldn't get a service. If you decided to go to another state and get the service, that employer couldn't discriminate against you. That's what it protects. So it's not about providing the service or not providing the service. It's whether the employer or the housing authority or the accommodation lead discriminates against you because you went and got those services. That's what it's about. And that's the point it makes, is that we're not saying you have to provide the services. We're saying you can't discriminate against people who get them, who find a way to get them.
And clearly this ends up with nothing in this division shall be construed as requiring an employer to provide health insurance benefits for sexual or reproductive health products or any services. So therefore, we're already saying you're not on the hook to do any of these things cost-wise.
To provide them, right? But you can't discriminate. That's what this adds.
Yeah, I got that.
Yeah.
If every couple of years the administration keeps coming up with a laundry list of things like this just seems like a slippery slope where you just keep walking down that, this to the laundry list, and this to the laundry list, and this to the laundry list. and we've gotten 2 cases maybe since this inception. What's the real purpose here? I mean, is it really an anti-Dobbs thing, or is this just to look like we're doing something in the media?
Through the chair, Councilman, I appreciate that question. I think, as I said, we do want to make a statement that this is a major policy change that the country's going through. I think you've probably read about some of the medical decisions that have been impacted by this policy change. I'm hearing anecdotally from local doctors trying to deal with individual situations that they feel constrained. I think it's the worst thing in the world to not be able to address your health, your legitimate health needs in the way that you would want to. So I think it's an important value for the county to say you shouldn't be discriminated against for that, for getting your health needs taken care of that you need to get taken care of. And making that statement is something other jurisdictions have done. And to your point about the Human Rights Commission, I think that we provide that avenue. I think that's still important. I think it was important for the other areas that we covered. And what's happened now, again, from that practical health perspective, we want people to feel like they can seek out health services without their job or their housing or other things being at risk.
So we're going to be in the middle of whether contraceptive decisions, sterilization decisions, we're going to be in the middle of all of that. Should there be some secondary aspect to the employee being let go, are we going to see these crop up as an issue that will get risen to it just so they can have an access to the Civil Rights Commission? It just seems to me that I just can't even fathom that the private industry is going to waste any time trying to worry about these things. It just seems like we're creating a problem. We're writing up an ordinance, we're putting it on the books, and it just doesn't sound like it's a problem that's sitting out there.
Mr. Chairman of the Council, I appreciate what you're saying about the employment discrimination process and how that works. Again, I think providing this affirmative type of protection is worth the cost. It makes a strong statement, and it allows someone who wants to bring their case out into public to be able to do that. I think it's sort of a modest step by us. Again, it provides this avenue. It says that we are aware of this kind of concern, and we're gonna create this avenue. So it's a value. It's something I think that's worth providing.
I just am concerned about the slippery slope we're keeping going down. Thank you.
Councilman Miller and then Councilwoman.
I'm actually, Mr. President, to Director, going to follow up on Councilman Schron's line of inquiry in a little different way. My question is whether you are aware of or can give examples of discrimination that you're aware of having occurred that would fall in under this section.
Through the chair, Councilman, no, I'd have to just give a possible example or theoretical example. Again, an employer who does not feel strongly about, say, this issue, and finds out that an employee went to another state to get health services, and then that employer takes adverse action against the employee just as a result of that. That's the kind of thing that I think is not a completely unimaginable circumstance. And I think it makes sense as a value to say these kind of healthcare decisions are about healthcare, are personal and in many ways practical. And we're going to support the idea that you can do that without that kind of consequence.
Thank you.
So if I may, so just so I understand, we are trying to foresee a problem that we really can't say there is one yet, if there is ever at all. And we're also saying that ABC company has an employee who asks for maybe several days off to be able to travel and go and recover and come back. That we're assuming or we're thinking that employer is going to say, I know what you really did, and you're fired for it. Is that really what we're kind of hanging our head on?
Through the chair to the Councilwoman, again, that's the employment example. I mean, there are the other examples too. I think the advocates that we've talked to, obviously the City of Columbus, and I know there are other jurisdictions have done this as well. I think there are other people that see this as a potential risk. And I think you could also say when you put something like this out affirmatively, maybe you prevent that kind of thing from happening. Maybe you send the message that this is not appropriate, that your local government has your back, and you can expect that you can seek out these kinds of services without that risk. Like I said, Councilman, I appreciate your thought about what's possible, what's likely. It's a fair question, but I think making the affirmative statement is legitimate, and I think it is a good value for the county to uphold.
And if I may, and did I read, and I'm trying to look for it again, you know how you read it and then you go past it and you try to look for it again. Is there a 5-day timeline where from the time that they're feel like they've been discriminated to the time that they need to make the complaint? They have 5 days to do that.
Councilman, I'm sorry, I don't know the tolling. I don't know if you do.
I read that somewhere.
Mr. Director.
And I tried to to re-find it again, but I thought there was a 5-day time. I mean, what kind of timeline are we under? How many days does that, or weeks or months does that person have to?
Councilman, it says it's in there.
What page are you on?
Well, there is a mention of 5 days. I'm on 15. I don't know if that's what you're referring to. It's actually on page 16.
16.
A complaint alleging discrimination. A complaint shall, under section of this title, shall be filed with the commission within 150 days after the alleged unlawful practice. So it does provide about a 5-month window there.
So that's 5. So 5 months later, that same person can come back and say that I've been discriminated and I'm losing my job. Is that what we're talking about, a loss of job or just being harassed or?
Well, again,
or
housing rights, employment rights, and then public accommodation. So those are the areas. And I would say the tolling or the amount of time involved is maybe you don't discover the reason, maybe the action takes place and you don't know, you figure out why later. But that's, I assume that's what's behind that.
Okay. I'm not sure where I can ask.
Mr. President? I want to talk about slippery slopes. And when we're talking about slippery slopes, I think I want to start with the Dobbs decision, how that eliminates 50 years of a constitutional right to privacy and to a woman's right to choose. This provides simply an avenue for an added protection from those rights being stripped away. Slippery slope of the next thing we know is birth control. Slippery slope is all kinds of things that happen when you take away a constitutional protected right to privacy. So when I look at this ordinance, it's only a minor way for a woman to have redress in this county. And I think it's really vital and important that we provide everything we can to women who are, in my opinion, under attack. So there's no slippery slope here, but an added protection. And certainly if somebody has a complaint, they can come here and waive their privacy right, as Councilman Tuma raised. So I'm in favor of this, and I think it's important that I, as a council person sitting here, does everything in her power to provide protection for women.
Let the record reflect Councilwoman Cheryl Stevens is in attendance. At this time, Councilman Schron.
Thank you. I think most businesses now don't even have vacation time or any of those things. They've all gone to PTO. No one ever asks the PTO, and it's probably written in every PTO policy. There's no need to mention however you want to use your time off. It's completely discretionary. So you would be violating their own internal company policy to use any of these provisions to take action, and therefore they would actually have cause of action against their employer right there on the face of it, without having this secondary issue out here. I'm not sure I read this. Can you tell me whether or not men are excluded from this?
As far as reproductive health decisions, I don't know.
No. Sterilization, contraception, those are all reproductive decisions also being made by the male. Are those covered in here too?
I mean, as you see, if you're on page 5, Councilman, the AA definition section there, it doesn't speak specifically to gender. I think it speaks to the services, the types of healthcare services that you would seek.
Okay, so if we're now saying we're going to interject ourselves in the middle of a contraceptive decision by the male also, and what actions and what steps they're going to take, things of that nature, is that reading this correctly?
Mr. Chair, to the Councilman, I don't know that it had that specific intent, but I'd say that certainly anybody could be involved in that decision or could potentially be impacted by discrimination in that area. So I think the definition is meant to be inclusive of anybody who might be in that situation.
So in other words, this
Mr. Chairman,
is much broader than Dobbs then? I'm sorry.
just for clarity, the county only inserts itself if someone feels they've been discriminated against based on that decision, and they file a complaint.
Right.
That's the only time the county would get involved, if the individual feels they've been discriminated against based on that decision.
I mean,
They come forward.
As long as you're doing what ifs, you can have a whole bunch of what ifs where two employees are dating each other, one impregnates the other, and they violated this, and they fire the male for failure. You can keep going your what ifs for a long way with the way this language is worded out there. I understand Councilman Simon's concern about the Dobbs decision, and I understand that that's an impactful decision. I don't know where we're addressing that in this language other than to get something in the newspaper.
Well, and as I said, Councilman, I think it's the fact that ability to seek healthcare has been impacted by that decision, and we're trying to help protect that part of it, that you should be able to seek healthcare and not get penalized or punished for it.
And I'm trying to tell you that PTO, no employer even asks what you're doing with your time off.
And again, I think there is a possibility of that not being a foolproof approach, and again, I think making the statement could have a preventative function too.
Further questions? Councilwoman?
Along those same lines, if, I don't know. So again, if an employee from a company takes their PTO and they're gone for 2 weeks and they come back and they engage back in their employment, I guess I just don't see where, especially because they don't have to express what it is they're doing. The employer could think they're in Hawaii or they could be anywhere. How is it, and then in 3 or 4 months down the road, this person doesn't perform their responsibilities and they're let go, then we're at the Human Rights Commission making an accusation that perhaps never really was the reason for the dismissal. I just don't know why we would get in the middle of that.
Well, through Chair, Councilwoman, again, I think it's like employment discrimination law and the process. You follow a process. If you have a adverse employment experience and you believe that this kind of one of these issues is the reason, then you come to the county, the Human Rights Commission, you go through the process, and it gets looked at and assessed. And again, as Greg said, hopefully it gets mediated. But it takes, just like in employment discrimination, it takes discussion and evidence and review to see what actually happened and make the best determination about who's in the wrong. So, I mean, again, that's if something happens, somebody has to bring it to us, and then it gets reviewed, and they make the best decision possible about what actually happened.
In the worst case scenario where a business just feels like you're taking advantage of me, I didn't do this, you're let go because of other reasons, I've got a file that shows lateness or whatever, not doing your job, how far can this go, and what would be the ultimate penalty to that business if they were found to be?
So again, if someone brought this to the commission, then both parties are engaged.
Right.
There's, I believe, some discovery aspect of it. I don't know, Greg wasn't sure, and I'm not totally sure, but the number $2,500 sticks in my head as a potential negative outcome for somebody who discriminates.
So where does that, where is that written, $2,500?
It's in the Human Rights Commission language, and again, if that's not correct, but that's I recall that. But as Greg said too, if somebody brings this forward, it can also be appealed to the county court.
Common pleas.
Common pleas. So it's another way to enter the system and get protection.
So it can escalate from the human rights to the fine to court action. Is that what
That is the path it would take, Councilwoman.
Okay. I guess I just want to say, we have a lot of small businesses out there that really can't afford to go through all that. And $2,500 is a lot. And if they are innocent in this, that's a lot. Again, another layer of difficulty to do business here in Cuyahoga County. Certainly, you don't want to see anyone discriminated for any reason at all. It doesn't matter what for. But I also think that we don't really have any examples of discrimination. I hear we have 2 over the time of this legislation, but we have nothing that has come before us. In this case, I think it's, like Councilman Schron said, I think it's something just to, and you said, make a statement, get it in the paper, let people know where we're at, and it'll probably end there. I'm not sure that there's really any driving need that we will see this enacted as soon as it's passed.
Well, Councilwoman, I appreciate what you're saying, and I like I said, I think having this kind of protection may prevent those kinds of adverse decisions. So I think there is a value to that.
May prevent something you think may happen.
Well, again, may prevent the real thing, or may prevent just a bad outcome in a health decision.
Okay.
Further questions?
Just one comment, Mr.
Yes,
President.
yes.
We've seen discrimination based on sexual orientation, failure to make a cake, failure to, maybe at some point somebody said it's far-fetched, this won't happen, it's unrealistic. And because those classifications are not protected under the federal statute, it was important that we have something in place here. Discrimination runs deep, and we're seeing the myriad manifestations of that in a lot of ways, and I wouldn't be surprised if we have a couple cases coming through here, and if it's, only a couple, that certainly is not impactful to businesses. There's no fear really of our small businesses in Cuyahoga County being under attack, but it will provide a safety net for maybe 1 or 2 people who end up being on the wrong end of discrimination. So it certainly does not hurt, and it helps. It provides protection. We already have the commission in place, and if there's an ability to dismiss a complaint, there's an ability to appeal, statutory appeal. So I don't see harm in this, but I definitely see a benefit.
Any further questions?
Mr. Chairman, I just want to correct one thing that was brought up earlier. We talked about deadlines for filing the complaint. And if the complaint is based on discrimination related to housing, it's actually 330 days in the current ordinance. And then all of the other 2, the employment or the public accommodation, that's 150 days.
And that's in that section.
Yeah.
330 is in that section too,
Yep.
on page 16.
Right.
Again, any further questions? All right, well, if all questions have been asked, I will entertain a motion to refer this to the full council for consideration for second reading.
I'll make that motion, Mr. President, and please add my name.
I'd like to second that motion.
Yes, let's add the councilwoman's name. It has been properly moved and seconded. Is there any further discussion? If not, all those in favor say aye. Aye. Opposed?
No?
I'm a no also.
Let's reflect 2 noes in Councilman Jack Strawn and Councilwoman Nan Baker. Those in favor, the ayes have it. All right, thank you.
Thank you.
Thank you. This time we'll prepare for executive session. All meetings of the Cuyahoga County Council are open to the public under the Ohio Open Meetings laws. Under that law, council may go into executive session during a meeting for specifically authorized purposes. During executive session, council confers outside of the hearing of the public. Council may not make any decisions about any matters in executive session. All decisions are made in public. This afternoon, the council will go into executive session to discuss a collective bargaining matter and purchase and sale of property. During this time, our live stream will be down, and we ask all those not specifically needed for the executive session to remain in council chambers. Council members will convene in the adjacent Committee Room A and will re-enter the meeting once the executive session has ended. Is there a motion to go into executive session for the purposes of discussing a collective bargaining matter and purchase and sale of property?
So moved.
Moved and seconded. Clerk, please call the roll on the motion to go into executive session.
Calling the roll, Mr. Sweeney? Mr. Tuma?
Yes.
Mr. Gallagher is absent. Mr. Schron?
Yes.
Ms. Conwell?
Yes.
Ms. Turner?
Yes.
Ms. Stevens? Ms. Simon? Ms. Baker? Mr. Miller?
Yes.
Council President Jones?
Yes.
The motion carries.
And
Mr.
Mr.
President?
Sweeney, would you like to weigh in?
Sweeney?
Yes, for Councilman Sweeney. All right, the ayes have it. We will adjourn for
Mr. President?
executive session.
Mr. President?
Yes.
The agenda suggests that pending or imminent litigation is also a topic. Is that still on this agenda, or was that removed?
Council President?
Didn't understand your question.
When you offered the motion, you said we're going into executive session for collective bargaining matters and purchase and sale of property.
Yes?
The agenda also lists pending or imminent litigation, but I've been hearing us going back and forth as to whether we're going to discuss that today. And if we are going to discuss that today, it should be mentioned in the motion.
Law Director, would you like to weigh in on that?
Yeah, Mr. Chairman, there's no litigation to be discussed today.
Okay, thank you.
We are now back on the record. We are reconvening this council meeting. Is there any miscellaneous business? No? If nothing else holds our attention, our meeting is adjourned. We will reconvene at 5 o'clock. All right. All right. Okay, good.